Mr. Banks, your lawyer has asked me to give you a PR bond. I will give you one final chance. If you ever take off again, I'm going to make your bond high. As you now know, no one is willing to bond you out because that's why you're stuck here. If you ghost us again, I'm going to make your bond even higher, and then you're going to be stuck like Chuck for an even longer time because I will never give you another one. You understand? Your case is 2,436 days old, your first DWI. We've given you you've had 3 surety bonds, you've had 2 PR bonds, and while you're out on the lam for this case, you pick up another DWI. And you and someone in their right mind sought fit to give you a PR bond, 2 PR bonds. They must live in outer space, whoever did this. Let's do first probable cause, and then we'll go from there.
Put your arms down now.
I don't understand what this says. This says defendant status deferred adjudication of guilt.
That must have been a typo.
It's got to be a mistake, right?
Yeah, gotta be a mistake. We're not on the first.
All right. Ma'am, you were charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, ma'am.
On January 13, 2024, officers were dispatched to an apartment complex in Harris County, Texas. Officers met with the complaining witness who stated the defendant arrived at his apartment and attempted to fight the complaining witness's girlfriend. Defendant then threw a piece of concrete at the balcony, damaging the balcony sliding door. Complaining witness stated the damage caused by defendant would cost approximately $500 to repair and replace. Complaining witness called the defendant and placed her on speaker. The complaining witness told the defendant she damaged the window, and the defendant replied, quote, "I don't give a fuck. I don't give a fuck. Don't play with me," end quote. Complaining witness identified the defendant by name and the defendant's Facebook to provide date of birth.
Ms. Ward, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand?
Yes, sir.
If you violate these conditions, I will put you in jail. You will not get any more PR bonds. We're going to reset the case to give you time to hire lawyers. So first, I'm going to have you go to Victoria, sign a reset. After that, you'll take a seat in the jury box. I'll get your bond conditions. We'll have you sign it, and then you'll be on your way. From now on, court starts at 8:30, not 11:02. Do you understand, ma'am?
Yes, sir.
Please.
Judge, page 2, Andrade, Jose. Just like, go ahead and sign for your reset.
Who's the last guy?
Jose Luis Bellman Andrade? They gave you a PR bond? That's cute. That's cute. Your case is 2,436 days old, your first DWI. We've given you you've had 3 surety bonds, you've had 2 PR bonds, and while you're out on the lam for this case, you pick up another DWI. And you and someone in their right mind sought fit to give you a PR bond, 2 PR bonds. They must live in outer space, whoever did this. Let's do first probable cause, and then we'll go from there.
If this courtroom trial has you hooked, make sure to hit that like button and subscribe for more intense trials and shocking outbursts. Your support means a lot to us. Thanks.
You're now stand charged with another DWI. We're going to do probable cause. You're facing yet another 6 months. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Please.
On April 5th, 2024, in Harris County, Texas,
Unbelievable.
deputy was dispatched to a suspicious vehicle call at Whataburger. Upon arrival, officer observed defendant in the driver's seat asleep with his foot on the wheel and the vehicle in drive. Deputy placed the vehicle in park and took the keys out of the ignition. Upon defendant waking up, deputy observed defendant to have strong odor of alcoholic beverage, a heavy, thick tongue, slow, slurred speech, drooping eyelids, and unsteady gait. Defendant refused SFSTs. DIC was read and defendant refused. Blood warrant was signed and executed. During vehicle inventory search, deputy located a 12-ounce Modelo beer unopened.
I'm going to find that there's probable cause to go forward with your case, Mr. Andrade, and I am now going to revoke your PR bond, and you will stay with me in custody.
Put your hands behind your back.
And I'll appoint you another lawyer today, and we'll see where we're going to go. But you know what, Mr. Andrade, Stephen, you signed an affidavit promising me that you were not going to drive. So I am now going to have a contempt hearing, and if they prove to me that you drove, you will be facing an additional 6 months in jail right now. So we need to do that, please. Thank you. Don't send them down, please. Do we know if the lawyers come in? Yeah, I guess let's try. And if you are unsuccessful, then I'll try. Mr. Banks, how's jail?
Not a place I want to exist in.
Why don't you show up to us?
Sir?
You don't show up to us. We had to revoke your bond because you went AWOL.
I didn't know nothing about provoking anything, sir. When I got released, I didn't even know nothing of a date.
They give you a piece of paper that you signed, Mr. Banks.
Yes, sir.
How you gonna try to play that?
I'm telling you the truth. I did not know nothing. I didn't know nothing.
Is discovery complete in Mr. Banks's case?
Yes, Your Honor.
If you put an offer on the case? Okay. Mr. Banks, your lawyer has asked me to give you a PR bond. I will give you one final chance. If you ever take off again, I'm going to make your bond high. As you now know, no one is willing to bond you out because that's why you're stuck here. If you ghost us again, I'm going to make your bond even higher, and then you're going to be stuck like Chuck for an even longer time because I will never give you another one. You understand? It is your responsibility to stay in touch with Mr. Brasher, your lawyer. If he tells me again that he can't get a hold of you, I will never do this again. It's now time to decide what to do with your case. Discovery is complete. It's time for you to meet with your lawyer. They're going to put an offer on your case, and by the next time we come back, we need to see what's going to happen.
Yes, sir.
You understand? All right. Do you have a good way to get a hold of him, Mr. Brasher?
No, I do not. I was going to see, Mr. Banks, do you have a cell phone number?
Yes, sir, I do.
Okay, what is it?
832.
On the reset we're going to give you today, it will have his phone number as well. So there is no excuse for you to say that you can't get a hold of him. I'm going to, in fact, circle it for you as well. Do you understand? This is your last PR bond. Okay, thanks. Thank you.
This courtroom didn't run on rage. It ran on real talk and razor-sharp accountability. Judge Fleischer didn't preach. He didn't rant. He just held people to the promises they made and the actions they chose. But here's the question. Should courts show this level of directness more often? Or is it too harsh for first-time offenders? Let us know in the comments. Thanks for joining us and witnessing this intense courtroom moment. If this trial got you thinking, be sure to like, subscribe, and share your thoughts below. Stay tuned for more gripping courtroom moments as we continue to bring you the most shocking trials. See you in the next one.